Under sections 14 and 4, subsection 5 of the Environmental Protection Act, the granting of environmental authorization was a condition precedent to the power exercisable by the minister under section 35 of the PET Act to grant a petroleum production license.
This was Justice Winston Anderson delivering his ruling on Thursday. The CCJ judge had to decide whether the Minister of Natural Resources acted unlawfully in granting the petroleum production license to the three added respondents in the case: Exxon Guyana Limited, Hess Corporation, and the China National Offshore Oil Corporation, known as Cnooc. Exxon was granted an environmental permit. Justice Anderson, in reference to the Environmental Protection Act 2009, concluded that the environmental authorization must be given for the undertaking of a project, and that the Environmental Protection Agency, known as the EPA, must be convinced that a developer can fulfill its role and responsibilities and comply with the terms and conditions of the environmental permit.
As sole operator, Exxon alone was able to comply with the obligations of the developer under the Environmental Protection Act.
In this case, Justice Anderson told the Apex Court that the PPL had been granted on the basis that Exxon was the operator of the project and was subject to extensive environmental obligations, which were extended to Hess and Cnooc through joint and several liability.
The essential requirements under Section 14 of the EP Act to obtain an environmental permit had been satisfied with the grant of the environmental permit to the sole operator of the Liza 1 project. It was consistent with international oil and gas industry practice that Exxon as operator functioned as representative of the joint venturers, that Hess and Cnooc be included within the license as financial partners to secure financing.
The ruling said that there is no basis for the Minister of Natural Resources, Vikram Bharat, to act unlawfully in granting the petroleum production license, known as the PPL, to Exxon Guyana Limited, EMGL, Cnooc, and Hess Corporation, when only Exxon was granted an environmental permit.
That there was no basis for finding that the minister acted unlawfully, and thus considered it unnecessary to address the issue of amendment of grounds of appeal, grounds of relief pleaded.
Justice Anderson reasoned that the appellant Raymond Gaskin acted as a public-spirited citizen with the intent of advancing the constitutional protection of the environment. The judge said that, quote-unquote, costs ought not to be awarded to Gaskin, who had challenged the PPL issue to Hess and Cnooc by former Minister of Natural Resources, Raphael Trotman. Back in February 2020, Acting Chief Justice Roxanne George threw out the case, ruling that Hess and Cnooc did not need separate environmental permits from co-venturer ExxonMobil/Esso, who was the developer, to conduct oil production here, and that the PPL was properly done. Dissatisfied with the Chief Justice's ruling, Gaskin then engaged the Court of Appeal, but was also unsuccessful in persuading the court. Antonio Day reporting for the AGP Nightly News.